Hi everyone, welcome back to my channel. Thank you so much for stopping by. Today's video is another requested video regarding the latest update in Johnny's defamation case against Amber in the US. So on the 10th of August, Amber filed her answer and grounds of defense. I will be linking it down below if you haven't read it already. I do know a lot of you out there have read it, but I won't be going through the answer portion of it because honestly, it's just a series of her denying everything that Johnny alleges and demanding strict proof of each and every one of those allegations, which is very rich of her to do, and I will get to that when I start talking about the grounds of defense. All right, so the way I've structured this is I have a response to pretty much each and every argument that has been listed in this section. Starting off with the first one, the plaintiff's complaint fails to state a claim upon which relief can be granted and requests relief which is not permitted as a matter of law. This one really confuses me because what they're essentially saying here is that Johnny has no cause of action. He has no claim for which relief can be granted. However, on the 27th of March of this year, the court did find and ordered on the 1st of April of this year that 3 out of the 4 statements that Johnny is relying on emanating from the op-ed have been found to be actionable. So earlier in the process, Amber filed a demur, which is basically an objection or a disagreement with Johnny's side of the story. So Amber's not denying the facts, but she's arguing or disagreeing with Johnny's allegations. So as I said, 3 out of 4 of the statements relied on by Johnny and his legal team have gone beyond the demur. So the objection to them has failed, and the court believes that these statements can potentially be found to be defamatory by a jury. And I do want to tell you that I have a very in-depth video with regards to the merits or the prospects of the Virginia defamation case coming up in the future, which is why I'm gonna hold back on delving too deeply into these aspects in this video, because I've already prepped that video and it's very detailed. I've worked very hard on it. So I do wanna save that information for that video. So to summarize this first argument, it fails because the court has already found that Johnny does have grounds for bringing a defamation claim against Amber. The second argument is that the op-ed was not false and defamatory because any statements this court has held relate to plaintiff were true. Essentially, they're claiming the defense of truth. Now, this is why I said it's very rich for Amber to demand strict proof from Johnny, because what we have here is her trying to tell the court that everything I said about Johnny is true, but I want you to take my word for it and dismiss the case without taking it to trial to determine whether the defense of truth applies or not. She's just as entitled to claim this defense as any other defendant to a defamation case, but you can't just expect the court to take your word for it in your answer on grounds of defense and just dismiss the case purely based on that. Thirdly, she claims that the plaintiff is a public figure and any defamatory statements in the op-ed were not made with actual malice. With regards to the definition of actual malice in the context of defamation in Virginia, actual malice doesn't mean any ill will or hatred or dislike or wishing someone harm. That's the everyday non-legal definition of malice when you do something with malicious intent. But in this context, it just means that the defendant, being Amber, made a statement either knowing it to be false or having a reckless disregard for the truth. So not caring whether it's true or not and still deciding to make that statement. This is, again, a factor that must be tried in a court by the trier of fact, which are the jury in this case. Simply submitting in your defense that there was no actual malice involved is not enough. The fourth argument is related to the third, and it goes on to say that Amber relied on counsel before writing and publishing the op-ed, and so therefore, as a matter of law, there can be no malice and therefore no action for defamation. It seems to me the argument here is because she allegedly obtained legal advice before writing this op-ed, which I don't even necessarily believe. We need strict proof of that, Amber. Then she claims that there can be no malice. But you can still make false statements or have a reckless disregard for the truth, even if you seek legal advice. It doesn't nullify that aspect. It doesn't completely cancel out actual malice. So I don't know what they're trying to say here. In the fifth argument, she essentially claims the defense of opinion or freedom of expression. So here she's relying on Virginia's anti-SLAPP statute. And if you've watched a bit of an older video I released a couple of months ago explaining why Johnny filed the claim in Virginia rather than California, it's essentially because Virginia's anti-SLAPP laws are nowhere near as strict as California's. If you want an explanation into what these are, please watch that video. It's entirely dedicated to explaining what anti-SLAPP laws are. Now, they've quoted the relevant section in the legislation. So essentially, this section would make a person like Amber immune from a claim of defamation based solely on statements regarding matters of public concern, which would be protected by the First Amendment. And then the second one doesn't apply, so I'm not going to read that. But this is the important part. The immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false, which is exactly what I just talked about a few minutes earlier, actual malice. So actual malice is pretty much defined within this section. This means that the case still must go to court, must go to trial, in order to determine whether these statements were made with actual malice and therefore are defamatory. It is a question for the jury to determine. So again, it is not grounds for the case to be dismissed before even being tried. The sixth argument is Amber essentially assigning all blame to Johnny for any injuries that he suffered. So any injuries he's alleging were entirely his fault, which seems to be Amber's MO. This is just what she does. She assigns blame to everyone but herself. Well, my response to that is, where's the proof, Amber? You need to prove these allegations. You need to prove that Johnny was responsible for his own injuries. And how do we do that? By taking this matter to court. The seventh argument is pretty much related to the sixth. So essentially, she's claiming Johnny is not entitled to any damages because he failed to mitigate his damages. So again, he's responsible for his own injuries and any damages that he may have suffered. The eighth argument is that Johnny is barred from recovery based on the doctrine of unclean hands. So unclean hands is basically a legal doctrine in which a plaintiff is barred or denied any relief because of any wrongdoing that they have committed in relation to the cause of action. So essentially, she is arguing that Johnny has committed wrong on multiple occasions, and I'm sure one of these is the alleged abuse that she suffered at his hands. So you shouldn't reward someone who has done wrong themselves, specifically with regards to the cause of action that is being brought. They're not innocent, as it were. Again, a legal doctrine that exists for a reason. She is entitled to claim it and rely on it, but it must be proven in a court of law. You see, there is a theme going on here where she spent pages and pages insisting that Johnny proves every single one of his allegations, which she is entitled to do. However, that applies to you as well, Amber. Both parties are required to prove their allegations, and that is entirely why trials exist. Otherwise, the opposing sides would just make their submissions in writing, give it to the judge, they will go through it, read it, and then make their decision. Why go to trial? Well, because that is how the legal system works. Trials exist to try both sides, to put their arguments and their submissions to the test and to prove their arguments and meet the required standard of proof, which in this case is on the preponderance of evidence. So it's not beyond a reasonable doubt. It's a lower threshold, very similar or basically equivalent to on the balance of probabilities in the UK. In the ninth argument, she claims that she did not write the title. And this is one of the statements, one of the three statements that the court found earlier in the year to be actionable. I don't remember coming across this argument that she never authored the title. To me, it's brand new. I could be wrong, and please let me know if you've come across it before. But this is the first time I'm hearing about it. And it is, once again, something that must be proved. Prove that you didn't write it. Bring the person or mention the person or subpoena the person who did author it. Because when you look at that op-ed, it says by Amber Heard. And this applies to her recurring argument throughout the answer, which is, I wrote this with the help of other people. Who are these other people? They're not named. As far as every member of the public who has read this op-ed, it was authored entirely by you. If there were co-authors, they would have been listed. I mean, I know ghostwriters are a thing, but I don't think they're a thing in articles. I think that's usually with novels and books and such. Correct me if I'm wrong, I'm not too sure on that. Whatever it is, she needs to prove that she did not write the title. And with regards to other people helping her write the article or the op-ed, that's irrelevant. You still wrote it. It was authored by you, as it clearly says on the website, and I'm sure on the hard copy as well, which I've never seen. So let's assume there were co-writers or ghostwriters in the background. That doesn't mean anything. That doesn't change anything. Johnny still has the legal right to bring a defamation claim against you, the named author. Now, argument 10 and 11 are basically her alleging that there is a 1-year statutory limitation to defamation claims, which is true, and that therefore Johnny can't bring up anything she said in 2016 to rely upon in this case. Now, I've read through Johnny's complaint, and he's relying on what is being implied in the article. And he brought the defamation claim less than 3 months, I believe, after the article was published. So well within the limitation period. And earlier in the year, in the same judgment in which her demur basically failed but for one statement, the fourth one, which was not found to be capable of being defamatory, so that objection was accepted. But the court found that this argument of hers fails, simply because, as I just said, the cause of action arises from the article, from the op-ed. And according to Virginia law, a new claim for defamation arises every time the defamatory statement is published. And as I just said, it was published less than 3 months before Johnny filed his claim. So that date of publication, which is the 18th and the 19th of December 2018, is when the clock started ticking. With regards to argument 12, I'm guessing it's in relation to the temporary restraining order or even the declarations that were made that year. But again, the source of defamatory material here is the op-ed, not Amber's declaration that was written 4 years ago. So it's really besides the point.